Hello there. The oil spill in the Gulf of Mexico scared the bejeebus out of Obama, who promptly issued a drilling moratorium for projects that drilled deeper than 500 feet. That, of course, had consequences for many people working in the industry and for companies like Transocean, the operator of the Deepwater Horizon drilling rig, for Halliburton, who did the faulty cementing job for the Horizon, and for other companies engaged in offshore drilling in one way or another. Bobby Jindal didn't like that and demanded that the moratorium be lifted. Indeed, several companies filed a lawsuit in federal court to which Judge Martin Feldman was assigned. Yesterday, on June 22, 2010, Judge Feldman issued an injunction against Mr. Salazar and others, lifting the moratorium, much to the relief of Halliburton, Transocean, Hercules and other companies engaged in drilling operations. Obama, scared that another accident could happen and put thousands out of work and, of course, jeopardize the environment, voted to file an appeal. Now, don't get me wrong. I'm torn between two extremes: the protection of the environment and the need of the workers to earn money. But then another oil spill would put tens of thousands of workers out of business again. Though this is not a simple issue, the problem I have is of an entirely different sort: the potential bias of the judge and the appearance of impropriety. According to a 2008 disclosure form, the judge in this case owns shares in dozens of companies that engage in offshore drilling operations. Indeed, Judge Feldman's disclosure report contains 10 pages alone on which his investments are listed. Let me name just a few with which I have a problem. First, there's Halliburton, the company which did the faulty cementing job for Transocean that caused the Horizon disaster. Next, there is KBR, a subsidiary of Halliburton. Then there is Transocean itself, which operated the Deepwater Horizon and allowed the Halliburton cement job and the faulty Cameron blowout preventer to be used. I'm not sure whether you follow me. Transocean is deeply involved in the oil spill disaster that triggered the moratorium, but the judge has no problem with owning Transocean stock. Next, there is TXCo, which sounds suspiciously like a company connected to Texaco, but then I may be wrong. In any case, TXCo is involved in offshore drilling operations. Next, there is Hercules Offshore, which is also involved in offshore drilling-related operations. I may be naive, but wide open to you educating me. How can a judge who owns shares in dozens of companies that engage in offshore drilling and related operations not be influenced by his investments, where the case at bar concerns a moratorium on offshore drilling? If you ask me, he should have recused himself. Indeed, under the Code of Conduct for federal judges, he had an obligation to recuse himself to avoid even the appearance of impropriety. But then I've been told that half of the judges in Louisiana own stock in companies that engage in offshore drilling. Take care.